Your Lordship, in this matter, earlier fixed date was granted by this Honorable Court of 1st of November. Your Lordship, it is to be argued by Shri Bharat and he is out of station today. So I am praying for any date, Your Lordship.
Madam, what is the case?
Sir, it's about my termination.
You are working in which department?
Judiciary.
Okay.
As a judge.
Acha.
Your Lordship will come to the last order which was passed. Lordship's query was very specific. What is the difference between...
Ji. This matter we have heard sometime.
Ji.
Oh yes. Madam, isko.
Yeah. Sir, regarding your query, which you said last time is to clarify the difference between dismissal and termination. And by this honorable court, recently a judgment is passed on 12th June 2023 in matter of Krishna Kumar Kosaria versus State of Chhattisgarh in para number 20, 21 and 22. In 22, the court relied on the learned Supreme Court's judgment on Motiram Dheka versus General Manager Northeastern Frontier Railway, in which the court found that has expressed that the said words mean nothing more or less than the termination of the service of a person's office, the effect of dismissal or removal of one from his office to discharge him from that office, that is to bring about cessation of service. Thus, the said words comprehend every termination of service of a government servant. Article 311, subclause 2, in an effect, therefore, lays down that before the service of government servant are terminated, he must be given a reasonable opportunity of suing cause against such a termination. And in para 21, the inquiry 22, the scope of the word dismissed and removed employed under Article 311 of the Constitution, India.
Madam, एक copy हमको भी तो दीजिए.
Yes. In para 23, my lord, the Supreme Court in the matter of Parsattam Lal Dhingra versus Union of India has held that mere termination of service without more of such an employee would constitute his removal or dismissal from service, attracting Article 311(2) of the Constitution of India.
Madam, you were on probation, na?
Yes, sir.
So, please tell us, see, when you are on a probation, all right?
Yes,
then, and he is a confirmed employee. So, what are the protection can be granted to a probationer employee? You are a probationer.
Yes, sir.
So, what is the protection can be granted to you by the Constitution? Please tell us the.
Sir, it is the safeguard is granted under Article 311, subclause 2.
How?
It says that if any.
You are not. See, please try to understand the things. When you are on a probation,
yes, sir.
What is your status? Please explain on this issue first.
Yes, sir.
And what is the law which provides that the probationer has to be protected in what manner?
Yes, sir.
You are taking the judgment that will not help you. Prima facie, I tell you.
Yes, sir.
You are. Please go and search some judgment on probationer.
Yes, sir. I have searched.
Yes, please tell us now. Come to that judgment. Yes, directly to this judgment. Yes. What is this?
This is judgment passed by the Honorable Supreme Court in the matter of Registrar General High Court of Gujarat versus Jaisli Chamanlal Buddhabatti. In this case,
which paragraph you want me to read out?
Paragraph 28 it says that having gone through the silent judgments on the issue in hand, one thing which emerges very clearly is that if it is a case of deciding the suitability of a probationer and for that limited purpose any inquiry is conducted, the same cannot be faulted as such. However, if during the course of such an inquiry any allegations are made against the person concerned which result into a stigma, he ought to be afforded the minimum protection which is contemplated under Article 311 subclause 2 of the Constitution of India, even though he may be a probationer. The protection is very limited, which to inform the person concerned about the charges against him and to give him a reasonable opportunity of being heard. Having noted the facts as they have emerged on the record, can be preliminary inquiry conducted against the respondent. In the present case, we said to be an innocent, one only to assess her suitability. Is it not apparent that certain aspirations were cast on the character of the respondent during the course of the conduct of this inquiry on her suitability? If that was so, was it not expected from a high judicial institution like the High Court to afford her the minimum opportunity to defend herself? In some sense, this court has observed that subordinate judges are under the care and custody of the High Court. This custody and care certainly requires the High Court to afford the subordinate judges the minimum opportunity which is otherwise available to every other civil servant under Article 311 subclause 2. My lord, this case is similar as my case because while deciding my confirmation, the standing committee, while the standing committee dealing with the confirmation of my service, it took in annexure R21, page number 408 of this paper book, certain matters were taken by the standing committee on its meeting held on 31st January 2017. In that, first thing was that I filed a complaint against then district judge on 25th April 2016. That was dropped in that meeting. This meeting was held for the regarding the confirmation to decide the confirmation about my job. And the second thing was there were 3 complaints that was taken by the standing committee. That is in annexure R24, page number 414, in which first complaint is comment stated 30th January 2016, submitted by then District Judge Ambikapur regarding complaint dated 30th December 2015 by Anju Gupta, ADPO, against the petitioner. There was one complaint she filed against me. In that, it is humbly submitted by the petitioner before this honorable court that above complaint was filed by the Anju Gupta, ADPO, on 30th December 2015, and the comment on the same was sent by the respected District Judge Ambikapur on 30th January 2016, as mentioned in annexure P21, page number 366 to 369. But no action was taken against the petitioner till 31st January 2017. Till 1 year, there was no action taken against me. But it was taken at the time when my confirmation was about to decide. That time, the standing committee took this complaint before it. And this complaint was filed before the extension of my probation. But when we see the specific order, standing committee in its meeting on 24th January 2017, it's mentioned in the annexure R21, page number 408. That time, standing committee directed the Registrar General to keep ready the entire service record of the petitioner with 9 other judges of her bench, in my bench, especially after the extension was granted. This complaint was before the extension was granted to me. This complaint was in December 2015 and my extension was on 18th March 2016. And then second complaint was also taken. That complaint was made by the then district judge Ambikapur against me on 30th April 2016. It is pertinent to mention that before this 30th April 2016, I myself filed a complaint against then CJM Mr. Varial against about his conduct, but he no action was taken by district judge, and then he complained. He filed a complaint against me before the Registrar General, and this was taken at the time of deciding my confirmation before the standing committee. And the third complaint was taken by this standing committee is a complaint 10th May 2016 by one R.S. Sukla, ASI. He complained against me, and that complaint was taken at the time of deciding my probation. And this complaint was also made after I complained against Mr. Varial, and also against when I complained against Mr. Varial and the district judge Ambikapur at that time. I also complained about because he has not taken any action against that CGM. I complained about district judge and CGM before the portfolio judge because no opportunity was given to me. So all these complaints were taken at the time of consideration of my probation. That's why I have to get this protection under Article 311 Clause 2 because the complaint were taken. So therefore this case of Registrar General High Court of Gujarat and Justice Chamanlal Buddhabhatti is applicable.
Now, subsequently, the Honorable Supreme Court has also taken some other view in 2019 or 18. You have gone through with the judgment of it is arising out of, I think, Rajasthan se hai shayad. You just check up it up.
22.
Yes, I think.
Yeah, it's Abhay Jain versus.
Yes, what he says?
In this case, the matter was also about this additional. He was
on a probation.
Sorry.
He was on probation.
Yeah, he was also in probation.
Where you copy hai aapke paas?
Yeah.
Madam, don't tell yes, boliye.
Sorry, sir.
We are living in Hindustan.
So, sorry.
Doesn't look nice.
Sorry, sir.
क्या बोलता है इसमें?
Sir, in this case, Abhay Jain was appointed as an additional district judge in year of 2013, and he was while dealing with some bail matter, he has given bail, and that was complaint against him. He was in probation for 2 years, before. And one anonymous complaint was filed against him stating that after rejection of the High Court on that particular bail, he granted the bail. And my lord, kindly see the page number, the last page. In para 71, the Honorable Supreme Court held that to conclude, we are of firm view that in the present case, there was no material to show cause unsatisfactory performance of the appellant in terms of requirement under Rule 45 and 46 of the RJS Rules 2010. Moreover, the
Mr. High Court, you tell us
what
are the rules to record a finding whether the performance of the petitioner is satisfactory or not? Whether any statutory rules have been framed, which says how the performance appraisal has to be made, what is the pendency of the, what are the parameters laid down by the rules made in this, you have to tell us on the next appeal. Yes.
My lord, in this case, Moreover, the appellant's discharge was not simpliciter as claimed by the respondent. The non-communication of the ACRs to the appellant has been proved to be arbitrary, and since the respondent choose to hold an inquiry into appellant's alleged misconduct, the termination of his service is by way of punishment because it puts a stigma on his competence and thus affects his future career. In such a case, the appellant would be entitled to the protection of Article 311 subclause 2 of the Constitution. Moreover, the adverse comments on the ACR for the year 2015 would not have been the basis on which the appellant was discharged from service. The appellant was never granted an opportunity to improve, and there was no intimation to him about his performance being unsatisfactory. This case is also relevant to my case because my ACR of 2015 to 16, in which adverse remarks are wrote in about me, that was communicated to me after my termination, 10th April 2017. That was communicated to me.
When communicated to you?
10th April 2017, and that is the ACR of 2015-16. And my lord, regarding rule, there is a rule also, rule of the High Court. The Chhattisgarh Judicial Officer Confidential Rule Regulation 2015.
When this rule have been made effective?
2015.
No, these rules are 2015, but when it has been made effective? The date must be given. 27/1/2015. Yes.
In that rule, your lordship, regulation number 7.
Yes.
Regulation number 7 speaks about
communication.
Yes, my lord. Preparation of ACR and its time limit.
Yes.
And it's subclause 4, the ACR submitted by the reporting authority shall be made available to the concerned reviewing authority by 15th May. My review authority is the portfolio judge.
Portfolio judge, yes.
Sir. Note, its note says every endeavor shall be made by the authorities in early finalization of confidential report so as to enable the authority to communicate the final concluded confidential report.
Who are your reporting authority?
My reporting authority was the district judge.
District judge. And
reviewing authority is portfolio judge.
And
portfolio.
What is the role of the Honorable Chief Justice?
Sorry, my lord.
Whether the Honorable Chief Justice is accepting authority?
Yeah. Sorry. Yes, sir.
How? Whether it has been defined in the rules?
I think Schedule 1 is not attached with this rule.
Yes.
Schedule 1 is there.
Yes,
Schedule 1.
Yes.
Schedule 1, 7th, serial number 7.
Yes.
Judicial officer subordinate to district judges of concerned district. District judge is reporting authority. Portfolio judge of the concerned district is reviewing authority. And accepting authority is Chief Justice.
Yes. Chief Justice is accepting.
Chief Justice.
What was the what was the comment of the this review authority? Whether he has agreed with the opinion given by the reporting authority?
Yes, sir.
But the ACRs is not a ground for you to not to continue in the service. They have not taken care. They have not taken into consideration the ACRs while not continuing or while discontinuing your probationary period.
But my lord.
So see, this point will help you out. Please tell us. Your services were discontinued, terminated, non-probational period is not extended. When the date of order was passed? When the order was termination was passed?
9th February 2017.
2017. ACR was communicated to you on 1/4/2017.
10th April
10th.
2017.
Whether while not continuing with you in service, they have taken into consideration the ACRs of you or not? Tell us.
Yes, sir. Because it's
Where is the, please read out the order of termination. Please read out the order.
order of termination.
Yes, please.
Yes.
Read out.
Kindly see page number 49 of paper book.
Yes, पढ़िए.
The government of Chhattisgarh, accepting the recommendation of the Honorable High Court of Chhattisgarh, made in accordance with the sub-rule 4 of Rule 11 of the Chhattisgarh Lower Judicial Services Recruitment and Condition of Service Rules 2006 for termination of services of Kumari Akanksha Bhardwaj, member of Lower Judicial Service, presently posted as Civil Judge Class 2 Kankher, hereby terminates the service of above mentioned Kumari Akanksha Bhardwaj with immediate effect.
And what was the recommendation of the full court?
There is no recommendation by the full court, my lord.
No, it will be.
There is only a standing committee who recommended my termination.
What was the recommendation?
Kindly see page number 409.
Yes.
Resolution second says the standing committee considered the overall performance and entire service record of Kumari Akanksha Bhardwaj. On perusal of the record, it is found that she is not fit for confirmation in service. Therefore, it is resolved to recommend termination of her service under sub-rule 4 of Rule 11 of the Chhattisgarh Lower Judicial Service Recruitment and Condition of Service Rule 2006. This recommendation was made by standing committee, my lord. And it also says entire service record of Kumari Akanksha Bhardwaj.
So whether entire service record means your ACR has to be taken? See, ACR and this entire service record are altogether different things. Means whether this order doesn't speak about that your ACRs have been taken into consideration. So I don't think that will help you out at the initial, at the moment. Once whether the performance assessed by the standing committee is justified for termination or not, that has to be submitted by the High Court. You are saying that you have taken two stands. One is that as per the judgment passed by the division bench of this court, the standing committee is not empowered to terminate. This is your one leave of argument on the last date of hearing?
Yes, my lord.
The second is that standing committee has considered the record and no opportunity of hearing has been given to you. These two limb of argument is there.
Yes, my lord.
This is only 2 points you want to emphasize?
But kindly see the ACR communicated to me.
In the year 2017 after termination. After discontinuation of your probation period or non-extension of your probation period. The appropriate word will be non-extension of probation period or dismissal, termination, whatever the name is. But these 2 points mainly you are emphasizing that the standing committee has no power in view of the rule 4(3) of the rules of High Court rules.
Yes, my
the standing committee cannot issue the order for termination.
Yes, my lord.
One is, and the entire service record has been considered, but no opportunity of hearing has been given to you.
My lord, one more thing is that not entire service record was taken.
You want to say that? Likhna, the petitioner in person would submit point number 1 that the standing committee is not empowered to recommend it for termination in view of the rule 4(c) of the High Court of the rules, High Court rules 2007. As such termination is bad in law. Number two, she would further submit that the entire service record has not been taken into consideration.
Yes, my lord.
And therefore recording of finding that performance is unsatisfactory is contrary to the record.
Yes, my lord.
As such, the recommendation is bad in law.
Yes, my lord.
Third point is since they have taken into the consideration certain allegations levied against the petitioner, therefore at least she must be given an opportunity of hearing
Yes, my
to
lord.
defend herself.
Yes, my lord.
This is your 3 points, huh?
Yes, my lord.
All right. Yes, state.
Lordship, at the outset, I have submitted that it is to be argued by senior advocate Mr. Bharat.
Where is he?
Your Lordship, today he is unavailable, and a fixed date was granted earlier by your Lordship of.
Yes, we'll give a fixed
Any
part
date.
heard.
Yeah.
Argument heard. Madam, this is your argument?
Yes, Your Lordship.
Madam, why don't you prepare synopsis of your case?
Yes, lord. I have already prepared.
Give it to us. The petitioner has already submitted his written synopsis
Sure.
also. A copy भी आप उनको भी दे दीजिए. Mr. Vankhade would submit that his senior, Mr. Praful Balat, is not available.
Harshvardhan.
Mr. Harshvardhan would submit that his senior is not available today. Therefore, he prefers short adjournment. Argument heard in part. Madam Bharadwaj has already argued the matter. Please this case on for further hearing on 27 January. 27 January we'll hear finally.
Okay.
Yes. मैडम वो डिवीजन बेंच के जजमेंट है उसको बता दीजिएगा तो
Yes, my lord.
वो
All judgments are there.
दे दीजिए give it to us.
Rules of
High Court rules.
yes.
दे दीजिए सर्विस रूल
Yes, sir. Sir, lower judicial
दे
service.
दीजिए. Whether any amendment is made in these rules?
I didn't find any
You have searched it out?
amendment.
Yes, already. Give it to us.
Only about the pay scale there is amendment.
Yes,
Now pay scale is higher.
all right. Then आएगा. In person or through his counsel, if so advised, according to convenience of the petitioner. Yes. Argument heard in part, Mr. So लिख देना. List it on 27 January or final disposal in motion.
Thank you, sir.
Film 13 and 14, see Ashish Surana.